All present.
Mr. Sumit, because Justice Manmeet is sitting here, so he has gone in. जो लास्ट वाला रो है ना उसमें फर्स्ट सीट में सेकंड वाला जो आगे की तरफ होके बैठा
That one.
Yes, please.
Namaskar. Good morning. Welcome to the first session of today and the second last session of the Delhi Arbitration Weekend on the role and duties of experts in assisting the Arbitral Tribunal. I request the chair of the session, Honorable Mr. Justice Vikram Nath, Judge Supreme Court of India, the speakers, Honorable Mr. Justice Sanjib Banerjee, Chief Justice, High Court of Meghalaya, Mr. Jimmy M, Mr. Montek Mayal, and Mr. Sumit Khosla to kindly grace the dais. Arbitration proceedings most often involve complex disputes which require specific technical, scientific, legal, or financial expertise, leading parties to appoint one or more experts to support their position and assist the arbitral tribunal. An expert is mostly any professional having an in-depth understanding of the subject matter and is instrumental in providing a view on the quantum of damages or losses incurred due to the alleged breaches being arbitrated. Role of an expert, however, goes beyond merely providing an opinion. It involves deciphering the relevant facts through documents provided or from information available in the public domain. She also acts as an interpreter, couching technical aspects in the dispute into simpler terms. This session shall focus on the present status of the law with regard to the appointment and role of experts, which finds reference under the Arbitration and Conciliation Act 1996, and the evidentiary value of expert witnesses, which is governed by the Indian Evidence Act. Today's session is being chaired by Honorable Mr. Justice Vikram Nath, Judge Supreme Court of India. About our speaker, Sir was enrolled with the Bar Council of Uttar Pradesh in March 1987. He was elevated as additional judge of the Allahabad High Court in September 2004 and took oath as judge of the Allahabad High Court in February 2006. He was elevated as Chief Justice of the Gujarat High Court in September 2019. Thereafter, Chief Justice of the High Court. He was the first, in fact, Chief Justice of a High Court in India to live stream court proceedings. He was elevated as a judge of the Supreme Court of India in August 2021. Welcome, sir. Our speakers, we have Honorable Mr. Justice Sanjib Banerjee, Chief Justice, High Court of Meghalaya. Sir was enrolled as an advocate in 1990. He practiced principally in the High Court of Calcutta as well as in the Supreme Court of India, besides other high courts and tribunals, primarily in civil, company, arbitration, and constitutional law. He specializes in corporate and intellectual property law matters. He was elevated to the bench of the High Court at Calcutta as a permanent judge in June 2006. He assumed the office of Chief Justice of Madras High Court in January 2021. Thereafter, he was transferred and took oath as Chief Justice of the High Court of Meghalaya in November 2021. We have Mr. Jimmy M. Mr. Jimmy M is a senior counsel and chairman of Drew and Napier and was the managing director of Singapore's most celebrated dispute resolution practice group for 15 years. He has over 3 decades of experience in civil and commercial litigation and international arbitration involving high stakes, multiple jurisdictions, and renowned parties. His experience in trials and international tribunals arbitration ranges from energy projects, buildings, constructions, joint venture, infrastructure, telecommunications to technology. Our third speaker, Mr. Montek Mayal, is a partner at Osborne Partners. He founded and has led the firm's Asia and Middle East practice. His previous role, he was a senior managing director in FTI Consulting, Economic Consulting and International Arbitration Practice. His range of experience includes shareholder and joint venture disputes, private equity disputes, intellectual property disputes. and also M&A and post-acquisition disputes. Our fourth speaker, Mr. Sumit Khosla, is a partner at Accuracy, which sits across Europe and India. He has over 20 years experience in the transaction space and specializes in cross-border transaction advisory. He started his career in 1993 with PricewaterhouseCoopers Paris as a financial advisor, before moving on to PricewaterhouseCoopers London as a manager within the Transaction Services Department. He went on to work for more than 10 years for the PPR Group, a French multinational, before joining Accuracy. He headed the corporate finance practice of Mazars India for 4 years. Welcome, sirs. I invite Honorable Mr. Justice Vikram Nath, Judge Supreme Court of India, to take forward the session. Please, sir.
A very warm good morning to all of you present in this auditorium. My esteemed speakers, panelists, Chief Justice Sanjib Banerjee, Mr. Jimmy M, Mr. Montek Mayal, Mr. Sumit Khosla, my esteemed brother Justice Ram Subramaniam, I think he just left for his another session, brothers and sister judges of the Delhi High Court, distinguished guests, ladies and gentlemen. So today is the last and the fourth day of the Delhi Arbitration Weekend, organized by the Delhi International Arbitration Center. And 16 sessions have already been over. This is the 17th, and the 18th is running parallelly in another hall. I believe all of you must have gained tremendous amount of knowledge and benefited from these sessions. And I am sure, and I assure all of you, that in this session also we will get a lot of meaningful and positive discussions which will help all of you. So today's topic for this session is role and duties of experts in assisting the arbitral tribunal. Now, of course, all of us, all the panelists here and myself and all the gentlemen sitting here who have partners at home, without meaning any offense and with due respects to all the ladies present here, that we deal with a lot of complex problems at home, which could be starting from cooking to dressing to finances to science and everything. You don't need an expert because you have somebody at home who is an expert in everything. But in tribunals outside home, we do need experts to sort out all these complex issues of which we are not aware. So first question which comes is, whether do we actually need experts? The answer would obviously be yes in many matters, but in large matters it may not be necessary to have an expert because there may not be any requirement of any such expert opinion. And the arbitrators would themselves be aware of what is the coming out from the record and what the lawyers would submit, and they can give their awards. But considering the nature of disputes being referred to arbitral tribunals, I personally believe that we do need experts in, depending upon the facts and disputes in each case. Of course, the Evidence Act acknowledges the expert evidence. Even the Arbitration and Conciliation Act 96 also provides for the arbitral tribunal to appoint an expert for specific issues framed by it. And even the parties are at liberty to appoint experts in order to convince or prove their point. At the same time, let me also deal with an issue that where there are diverse opinions of the experts, what is to be done. The arbitrator himself is not an expert. The lawyers appearing for respective parties may also not be experts. And how do they deal with these different opinions? One way to sort out is, as you call it, an expert witness conference, where you put all the arbitrate experts together, and then it's an open discussion between them, and the experts can cross-examine the experts and put questions to them and get an opinion. This is whether it is an acceptable or it is actually good for the arbitrator, like the arbitrators to deal with it. The parties may have an objection to it. But nevertheless, internationally, these kinds of systems are being accepted. And after a session of expert witness conference, there is a further concept of submitting a single final report, where all the reports are combined together and with the deliberations of all the experts, a single report is submitted to the tribunal to deal with it. These are all concepts which are coming up, and I'm sure the experts present here who would be speaking will further elaborate on these points. We now come to, I'm only giving an outline of what is going to be the discussion today, which will also include under what circumstances a report of an expert can be excluded. There are judgments, especially the Canadian High Court, Supreme Court, which lay down as to under what circumstances an expert's opinion should be accepted or excluded. If it qualifies all the tests laid down, the report may be accepted, otherwise it has to be excluded. There are twin tests in the Abbey's case, and there are 5 guidelines laid down in R versus Mohan's case. These experts would be deliberating on that, elaborating them. I will not take much time on that. One of my concerns is whether there is a mechanism, which of course I will request my experts to speak on, not the experts, these panelists and the speakers, as to whether there is a mechanism of putting an expert to terms and conditions if it is ultimately found by the tribunal that the expert has misconducted himself. I can understand that an expert is not provided the complete material by the parties, but once it has all the material, whether the report submitted conforms to those tests or not, and if it is deliberately something has been concealed and a fair opinion has not been given by an expert, is there any system of addressing it, putting the expert to some kind of terms, maybe debarring him for some time being an expert in any arbitral proceedings or any such thing? We also have framed a lot of questions, and of course to which answers would be given by the speakers, like what are do's and don'ts for an expert, and many other questions will come up. I will not read them out this time. They will come up as the deliberation goes on. So without taking much time for a few, and rather having the speakers convey their respective opinions and their sharing their knowledge with us, I would request now Justice Sanjib Banerjee, Chief Justice of Meghalaya High Court, to give his viewpoints. He may speak from there because I felt a little uncomfortable, speaking sitting, and standing it's better, the impression goes a little different. And thereafter, Justice Banerjee will pass it on to Mr. Jimmy Yim and so on and so forth. And then we'll all be, attacking each other and getting some good results out of this session. Thank you.
Good morning and namaskar. Justice Nath, my fellow panelists, honorable judges from Delhi High Court, Justice Sundar from the Madras High Court, distinguished ladies and gentlemen. Somehow the word expert has become probably a bad word because it's a difficult choice. And indeed, Justice Nath, referred to the panelists as experts and quickly corrected it to panelists because that was probably a better way of describing them. The object of the exercise here is how to make arbitration more efficacious. I have a prepared text so that I don't ramble. A system or a process may be said to be efficient if it is fair, effective, affordable, and swift. To begin with, it must be appreciated why parties refer their likely future disputes to arbitration and not before the sovereign court or like designated fora. Some of the obvious advantages of a private forum are a less cumbersome procedure, the dispensation of the usual formalities, and the confidence in the forum's ability to appropriately adjudicate the disputes. Apart from the obvious inclination to avoid courts' delays across jurisdictions, more often than not, it is the complexity of the transaction that prompts the parties to opt for an agreed private forum of adjudication. Though engineers, accountants, and other professionals rub shoulders with legal practitioners on arbitral tribunals, the overwhelmingly greater presence of career lawyers and erstwhile judges in arbitral tribunals cannot be missed. In several situations, as when forensic accounting is involved, or the issue pertains to the assessment of quantum, or involve fraudulent schemes like Ponzi, the expert witness is indispensable. Say the claim in a reference is the failure of a machine or a process to function up to the specified optimum level and the loss of profit as a result thereof. This would call for an expert's opinion. Similarly, when the transaction pertains to a process based on novel science, the basis of the science has to be established by experts. It is in such a scenario where complex methods or specific techniques need to be understood for the purpose of adjudicating the disputes that the need for experts arise. Traditionally, as in the court system, parties call their expert witnesses. However, experience shows that even the best of experts seemingly seeking to confine their oral evidence to the area of their expertise, they tend to indulge in a degree of advocacy to justify the cause of the party which is engaged the expert. This party affiliation cannot be missed even in case of arbitrators appointed on the tribunal. And it is bound to be and is only natural since no party will put up an expert who will riddle holes in such party's case. Further, when one party has introduced an expert witness, the other party feels obliged to call its own expert to render a view covering such other party's interest. Oftentimes, the appearing witnesses disagree on matters of technicalities, which leaves the adjudicators none the wiser. There has therefore been a trend to advocate experts appointed by the arbitral tribunal itself, or in case of institutional arbitration, to call any one or more from the panel of experts in a particular field maintained by the relevant institution. Again, here, unless the parties leave the choice of the expert to the tribunal itself, the tribunal feels obliged to consult the parties on the choice of expert, and that leads to disagreement, protracted hearings on the disagreements, and needless lot of time. Since, more likely than not, parties themselves are aware of the element of the extent of their entitlement or their liability despite the show of a larger claim or a much reduced liability, the party which perceives to be worse placed in the arbitration may resort to a more refined form of filibustering. A further but less attractive trend has developed in the members of the tribunals seeking advice from an expert without the parties being privy thereto. This has its own pitfalls and does not appeal as it is fundamentally opposed to the principles of natural justice, however fair or impartial the expert may be. A better option could be the hot tubbing of expert witnesses that Justice Nath referred to. There is another aspect to experts giving evidence. And the graver danger is that experts, depending on the stature of the expert and his experience, often deviate from the short and narrow and usurp the adjudication itself. Particularly when an arbitral tribunal is overwhelmed by the expertise and is minded not only to be guided by the expert's final opinion on matters of relevant detail, but even by his judgment. There is a fine distinction between the opinion on details and the judgment on the issue. It is therefore necessary to limit the use of experts, whether being put up by the parties or being called by the tribunal, with or without reference to parties, and eschew allowing expert witnesses unless absolutely unavoidable. In essence, it may be summarized that when an expert's view is relevant, this is not referred to the Canadian judgment from which this is borrowed, when the view is relevant for the adjudication and is indispensably necessary to assist the tribunal, a qualified expert of impeccable standing may be called, provided there is no exclusionary rule, party autonomy. Such expert may take care to stick to his area of expertise and be able to explain the nuances in simple layman terms. He must cover the material complexities of the process or the underlying science and demonstrate the reliability of the hypotheses by referring to universally accepted theories and principles found in acclaimed texts in such regard. The other pitfall is the use of experts also adds to costs and may even tend to hijack the focus of the reference from the key disputes to needless technicalities. In an article published in the National Law Review in its latest 15th of February 2023 edition, there is a reference to Lord Hodge delivering the keynote speech at the Expert Witness Institute's annual conference in 2021 and referring to a 2019 survey which found that 25% of the experts reported that they had felt pressurized to change their report in a way that damaged their impartiality. And 41% of the experts indicated that they had come across other witnesses that they considered to be a hired gun. The same article refers to an international arbitration survey conducted in 2012, in course of which it was discovered that in 90% of the cases involving expert witnesses, the experts were party appointed, but less than half of the respondents found expert witnesses to be more effective when appointed by the parties. The other aspect of the matter is the manner or form in which the experts and the experts aid the tribunal, whether in the traditional form of drafting an expert report and then testifying at a hearing, or by some other novel methods more recently adopted. There is, however, no available data on the comparative efficiencies. Doubtless, the panel discussion that follows will focus on some of the key areas pertaining to experts in international arbitration in particular. May I request Mr. Jimmy to continue and take us forward.
First and foremost, a very good morning, Justice Vikram, Nath, Justice Sanjib and Banerjee, Supreme Court judges, honorable friends, distinguished guests. I'm very honored to be here, to be able to attend the inaugural meeting, Arbitration Week of the New Delhi Arbitration Center, and to be able to speak on a very difficult subject. It's been said that in the many areas of practice of the law, the most difficult is dispute resolution and advocacy. And in the field of dispute resolution and advocacy, the most difficult part of it is cross-examining an expert witness who's giving an opinion against your client. And the reason for it is obvious, is because it transcends outside the area of our teaching and guide and experience as lawyers. We are only versed in the law. And so in this area, as you've heard the statistics, so often experts' opinions from differing sides are always at odds. And you're wondering, how is that so? And so I hope this panel discussion will review and discuss and examine this and the causes for it. And I think there's a good reason why Mr. Sumit Khosla, an expert who's on my left-hand side, is pitted right against Mr. Montek Mayal, right on the extreme side, because that's a classic situation of two valuation experts. And so on this Sunday morning, I think we'll have an interesting time to see how, on occasions, if they would be giving differing opinions, why would they be giving so, if we are all seeking to arrive at the truth of a matter. The definition of an expert is fairly known to all of us, and in the, let me just turn this on. Sorry. Yes. Could I help you with this? Yes. Okay. Right. The definition of who is an expert is provided for very clearly in your 1872 Evidence Act. And it's known to all of us who are in practice. Likewise, in Singapore, we have a similar provision as to who is an expert. Someone who is skilled from whether training, education, and or experience in fields of science, art, linguistics, or even foreign law, where an issue of that sort needs to be decided by the court or the tribunal. Now, he can't be just a generalist. He has to be an expert on the issue. So in that regard, the Indian Arbitration and Conciliation Act of 1996, Section 26(1), makes it a little clearer when it says this, that it says that the tribunal may appoint one or more experts to report on specific issues to be determined by the arbitral tribunal. So in essence, the expertise must bear on the issues that is going to be decided by the court or the arbitral tribunal. Now, this is an area where all counsel in cross-examination begins always to determine if the expert is truly an expert in that particular area. So I gave the example up there that you could have a valuation expert, say a chartered accountant or even a qualified surveyor, and they may be experienced in valuing all sorts of companies. But today we have the phenomenon of the fintech companies. Fintech companies are not the usual sort where you look at the past record of their earnings, you look at their track performance in the last few years. Many of them are startups, and many of them are loss-making. So when they listed Uber or Grab, those companies were negative. And yet there is no doubt that the valuers of these companies, including the stock market, will value them to be in the region of millions of dollars. So therefore, you can't take an ordinary valuer to try and value a company like fintech. You've got to ask if he has experience dealing in valuing fintech companies. Now, although the International Arbitration Acts and the institutional arbitration rules don't specifically provide for the duty of an expert to the tribunal, because it is commonly understood. Is a witness put forward by the other side to verify certain truths and facts of expertise. But the common understanding is that he is to assist the tribunal. But it is never stated in the acts and the institutional rules. It is just something that is commonly understood. In contrast, you will see that certain acts of various states will state that explicitly, that the duty is to assist the tribunal or the court. Now, it is in this area that I think when Justice Vikram Nath was speaking as to what sort of sanctions can a court or a tribunal impose for an expert witness who has somewhat misled the court or the tribunal. I suppose in the case of the courts, you have contempt of court, you have perjury. But in the case of an arbitral tribunal's award decision, even if he can shame the expert in the report, it is confidential, because that's the nature of international arbitration proceedings. It's confidential. So that would be another area I think this panel and the audience can discuss, how we can better improve the standards and uphold the integrity of experts in their duty to the courts. How do you get them? So the question is there self-regulation? Is there something that one can do within the institution of arbitrations? What does one do with these? Now, that would be a question I think we need to examine. Now, so because the arbitration rules and the arbitrations acts do not provide specifically the duties of an expert, lawyers and commercial parties often resort to what we call soft law instruments, so of which there is reference as to the duties of expert, one of which, of course, is the well-known IBA rules on the taking of evidence in international arbitration. So if you will see in Article 5.2, which I've reproduced up on the screen, it specifically says that what an expert report should contain. And of course, these rules are not applicable to any arbitration hearing unless the parties and or the tribunal ask for this to be adopted. So this has to be adopted. And when it is adopted, the expert report should have to contain the three things. First is that you must have a statement pertaining to the relationship the expert has had, whether present or past, with the legal advisors, with the parties, and in some cases, even with any of the other witnesses. Now, there's also a need to determine if they have acted regularly for the party concerned. Then there is a need for the expert to specify in his report what were the instructions he was given, and more importantly, what assumptions of facts he has made. Now, that is the one area in which you will find most amount of cross-examination or contention takes place. So often, parties may give only the facts that are in their favor to the expert, for the expert to give the opinion. And so, therefore, they will want to basically have an expert report that favor their side without revealing all of those other material facts. The question there is, should the expert, if his duty is to assist the court or a tribunal, go further than just taking the instructions given? Should he examine, investigate, and push the party appointing him to give him more facts? Now, in the Singapore High Courts and Court of Appeal, our judges have criticized experts for not probing the party who has appointed them. They have challenged those experts to say that you haven't done your part. If your duty is to assist the court or the tribunal and not just the party paying you, then you need to examine as if you have been, your primary duty is to assist the court.
You are an independent person.
Yes. So, in one of those cases, the judge says this, that an expert has to treat himself as if he were appointed by the other side. If his opinion is truly independent, his opinion should be as open to the other side as well as to the side appointing him. Now, that obligation, in my view, should be imposed if we're going to get experts to help courts or tribunals. Now, the third thing is, in this report, the expert needs to say that he has a genuine belief in the opinion he gives, and that he has been independent and impartial in giving that opinion. The Chartered Institute Arbitrators Protocol for the taking of party-appointed expert witnesses is even more explicit. Here I reproduce Section 4, or Article 4 of the protocol, and here expressly the expert's opinion is to be stated as being impartial, objective, unbiased, and more importantly, uninfluenced by the pressures of the dispute resolution process of any party. Just now, the statistics I heard from Justice Banerjee was very interesting, to say that over 40% of experts feel pressured by the parties appointing them. Now, if you look at the reality, if an expert gave a report, and of course these reports first come in the form of a preliminary report before they are filed. In the preliminary report, if an expert gave an opinion that doesn't favor the side appointing him, that side wouldn't appoint him, right? They would switch the experts. So there is no doubt that in practice, lawyers do some degree of expert shopping. If they got an expert that says something that they didn't like to hear, they thought that it would be against their client's case, you will see the expert appointed. So the question is, how should we go about ensuring the experts who are appointed would speak to it fully and still be on the job? Now, similarly, you will see that in the protocol for the use of party-appointed experts, you have the need for the expert to state his independence, his impartiality. Now, equally, we would recommend that for parties to use one or two of these protocols. But using these protocols don't solve the problem, because ultimately, by experience, although we've had many cases where these protocols are used, expert opinions still differ. So, therefore, the primary issue in the use of expert evidence is, how do we better improve experts to be truthful and to guide a tribunal or a court, given that the party appointing them wouldn't appoint them if they gave an opinion that would be contrary to the party. In Singapore, we have an innovation to this problem, because the judges are, no doubt like here in India, very alive to the fact that the number of times they have to deal with which expert opinion ought they to prefer on the same issue. So in Singapore, recently we passed the Rules of Court 2021, and the innovation there is that the default rule is that the court insists that the parties do not need party-appointed expert, but a single jointly appointed expert. And that expert, therefore, is not partial to either side, and that there is a declaration to be made by that expert. He has to declare that his primary duty is to the court and not to either party. Of course, by making this declaration, if he falls foul of it, you can imagine there are the powers of contempt and perjury. Now, will such an innovation that the Singapore courts apply be useful for an international arbitration? I think the present thinking that I have is that it probably not, because that runs contrary to the cardinal principle of party autonomy in international arbitration. Parties must be free to present the case as they deem fit. That's one cardinal principle. Two, select the witnesses they choose. So I doubt this innovation of the Singapore courts will find their way into international arbitration, but what does guidance and the truth of the matter on the issues at hand? Thank you very much.
Thank you. Thank you, Jimmy. Good morning, everyone. It's indeed a pleasure to be here and to share the stage with this distinguished panel. At the outset, I should say I'm going to disappoint Jimmy today. While Sumit and I might be sitting at the extreme ends, my role is that of a moderator today, so we won't have that many chances to disagree with each other. Justice Nath, Justice Banerjee, and Jimmy have given us the most appropriate context to help with today's discussion. We'll try to cover some of these points arising from their opening remarks in a bit more detail. In today's panel, we'll try to cover broadly three themes: the role and qualities of an expert, how one might use expert evidence in commercial disputes, and how might tribunals approach the use of expert evidence. And we'll try to make this into a conversation, so I very much encourage remarks from everyone on the panel on the various questions I intend to ask today. Sumit, I'm going to start with you. We have had some points on this already in the opening remarks given by everyone. But what, in your view, is the role of an expert? What are the duties of an expert? And how are they typically used in commercial disputes?
Thank you, Jimmy. Thank you, Montek, for the question. Yeah, I'm equally happy actually to be the same side of the table for a change with you, though the other end of the table, but we'll fix that later. I thought it might be useful actually to redefine together what the expert opinion evidence is about. And for that, I'll go back to an award actually from the New South Wales Supreme Court that was Capital Carpets versus Schwartz family that did define expert evidence as being a bridge between data in the form of primary evidence and a conclusion which cannot be reached without the application of this expertise. That's very interesting because if I feel the bridge cannot stand if the primary evidence N does not exist. In that case, the expert evidence is only a misleading jumble. Evidence can be in the form of official government records. It can be in the form of books records, in the form of companies' projections, forward-looking consensus by independent market players, but it does need to also include factual witness evidence and more importantly, and as a follow-up to Jimmy's comment, the opposing side expert evidence, which has to be taken into account. Just back to basics, I've tried to summarize, I don't know how to share the one slide that was prepared, just to summarize or illustrate what the duties of an expert may be. And we've taken the view that we were actually illustrating a quantum expert involvement in the context of a sequential submission process. So first, as you can see at the case preparation stage, the expert provides a document request list from his client. He then submits a first claimant expert report, then comes the a reversal report submitted by the respondent's experts, then comes a document production request stage from each parties. Here again, the expert's involvement can be quite significant. Then would come a submission of a second expert report from the claimant side, followed by a second response report from the respondent experts. Then at the pre-hearing stage, it is increasingly a market standard now to have a tribunal requesting both experts to produce a joint statements, which would come in the form of illustrating what the key areas of agreements and disagreements might be. At the hearing stage, then, experts' participation is naturally of a paramount importance through the cross-examination process, and then cross-examined by the other side's counsel, and then potentially, if the tribunal decides so, through a hot topic session, responding to tribunal questions together with the opposing side experts. And then finally, I just mentioned during the post-hearing briefs, the experts' involvement might be required by counsel just to make sure that these were consistent with the expert evidence that has been given. I would just like to add maybe one point to the duties of an expert. I think, Jimmy, you touched on competence, you touched on independence. I would just add transparency also as being a key duty of the expert. Transparency, meaning the ability actually of the recipient of an expert report to reproduce actually the analysis that has been provided, be it the other side, be it the tribunal, or the other side's experts in particular. So this, I think, is one of the other duties of an expert, is to be fully transparent in such a fashion that his analysis can be reproduced and would actually come or lead to the same conclusion.
Sorry, if I can just ask you, when you say transparency, are you referring to draft reports of the expert? Are you referring to discussions between the expert and the client or the legal advisors of the clients? Because there you have the problem of privilege.
No, I was actually referring to the level of detailing actually that comes along with the expert's conclusion.
Right, thank you.
Thank you. Thanks, Sumit. I think, just Jimmy, to your point as well, I think it's sort of consistent with the guidelines you're referring to, where essentially experts should provide the data they're using clearly, the analysis they're doing clearly, the underlying calculations that might support that analysis in a way to be more transparent, using Sumit's word, and trying to be more helpful, not only to other side's expert who's going to then use that analysis or perhaps critique it, but also eventually to the tribunals, because they might reach different conclusions on facts, and therefore the opportunity or the ability to sort of update or revise the models considered by one of the experts to reach their own conclusions, I think is quite important. I think increasingly in arbitration, where often the facts are so different between the two experts, a tribunal tends to find differences of fact to be applicable for any damages assessment. Yes, sir, please.
I have a question to the panelists here. Now, the parties are also have a right to lead evidence, and in that right, they can always produce their expert opinions. The tribunal also has powers to appoint an expert. Now, as Jimmy was just referring, because the expert would say that I have been paid by my client, by a party to give a report. Of course, I would be giving a report which will be favorable to my client, maybe irrespective of the fact whether it is, I don't know. So why can't we have something like the arbitral tribunal itself and alone may have the power to appoint an arbitrate to an expert after receiving the material from both the sides, the pleadings and the evidence which is being led other than expert, and thereafter necessarily frame a question and refer it to an expert, and then both parties share it equally. So the expert is also not, morally or otherwise kind of in a way obliged or, inclined to give a report in somebody's favor and against somebody. Can that be worked out? Is it feasible, this thing? The party's right to give expert evidence comes to the tribunal only. What do you say?
Well, if, Justice Vikram, if I understood...
That would bring more fairness and transparency. Right?
Yes, if I've understood the proposition you put, is that can an arbitral tribunal direct specific issues that require expert evidence to be assisted by an expert, which is to be appointed by the tribunal?
Yes.
Right. And that the expert, of course, may then be subjected to examination by both sides, counsel from both sides. And of course, yes, an expert can, a tribunal can do that, but then both parties, or at least either party, may then also ask for their own expert to be appointed, right? So then you then have a possible situation of a contest of three experts.
Then again, the same situation comes as the three expert opinions and each different from the other.
Yeah.
So if the tribunal itself appoints an expert and the report comes, then the counsels can cross-examine and thereafter...
Are you suggesting no appointment of experts by the parties, but only one common expert by the tribunal?
So there is no obligation of the expert on either of the parties.
Of course.
This is just a thought it came to me, and I said, let me have your views on this.
You almost jumped to my last question for the day. But I think it's at least what we see, and I'm sure Jimmy and Sumit will also have a view on this. Even generally, we see the use of tribunal-appointed experts to be quite low, very minimal in international arbitration. In fact, there's often a question posed that even from better decision-making, to help tribunals even decipher too often extreme expert reports submitted to them, they would benefit from having their own expert appointed, even sort of going one step further from what you're suggesting almost. But at least our experience is that that rarely happens. That rarely happens. In fact, I have only one of my matters out of 100 or so I've done, I've had a tribunal appointed expert. But I think there's a second question. There's a sort of protocol that was suggested almost a few years ago about how we do away with party appointed experts and appoint only one tribunal appointed expert. I think one of the questions that was raised in that context was, would that necessarily be the best analysis that we put forward? Because that expert's analysis will not be tested in a way which often is when you have two party appointed experts going at each other for months. But anyway, I know, Jimmy, you have a...
I think the short answer to Justice Vikram Nath is that in an international arbitration, you can't do that. A tribunal can't do that because one of the cardinal principles is party autonomy, the right to present its case. And one of the principal grounds for setting aside an award is the party will complain he was unable to present his case. And his case includes expert evidence that he wishes to offer.
All right.
So that's why I said the innovation by the Singapore courts is probably not likely to be easily applicable. But then having said that, it's a matter of the parties' agreement.
Yes.
A strong tribunal or a clever set of arbitrators might be able to get the parties to agree that only a single expert be appointed on specific issues to be agreed between the parties in a tribunal. If there is parties' agreement, yes, the answer.
But Jimmy, you also have, just building on that, you also have the process of expert determination, which can be agreed in the agreement itself, where in the agreement itself, you refer, like you said, certain questions that are likely to arise to a joint expert determination process. So valuation of shares is something we see quite often, for example, in the context of M&A transactions or private equity investments, where the intention, which often is, I think it often fails, but the intention is to appoint one expert on valuation, and that report is then binding on the parties for the purposes of the valuation. But again,
I think that's a clever way of getting around the problem by having it included in the agreement itself at the outset when the parties are negotiating it. Yes, there are such instances where you have in contracts where the parties agree to have an expert, right, to decide on the thing, and that there are procedures agreed between them as to how that single expert is appointed. But then, as you know, in the drafting of international arbitration clauses, that's usually what they call the midnight clause. After when all the important commercial terms have been negotiated, very few transactional lawyers who are responsible for drafting these clauses or the in-house counsel think through that clause. But this is clearly a clever mechanism if you can think ahead and draft it into the clause. Right, so I would imagine that in a massive, say, petrochemical plant to be constructed, there are numerous scientific and technical engineering questions that can arise in which parties can fall foul of each other's positions. You could provide for that.
Yeah.
But of course, that doesn't stop a party from subsequently asking for his own expert to be tendered in evidence, in addition to the single appointed expert. And again, subject to the clause saying that only one expert be appointed, and that either party is not permitted to appoint. I suppose if the parties are agreed beforehand, then they are bound by the agreement.
Well, I think you'll still find clever lawyers find ways around that as well.
Yes, lawyers will find ways around that, absolutely.
And I think there is case law. There's also case law, of course, in India, which gives you options to challenge that report on very limited basis, but yet that can be invoked, by, like I said, by clever counsel. You have a view on this, Sumit, before I move on? To
I mean, just to close on this suggestion, I mean, should such a provision be embedded in contractual documentation upfront? Yes, as Montek was just suggesting, there are ways to challenge also such an expertise on the back of very strict grounds, but that would not prevent you actually, that would not prevent the parties actually to be challenging this agreed upon experts.
So what also happens in certain arbitral tribunal hearings is that when the arbitrators feel that a very complex question had been raised, and despite the procedure that you saw, that the parties' experts are to have a conclave a meeting beforehand between them and to draw out a list of what they agree on, what they don't agree on, and subject later to a hot tubbing session, the arbitral tribunal may come to the view that they may need an expert to assist them. Yes. Now, again, whether or not that happens is driven by the need to get the parties to agree because of the concept of party autonomy. If the parties think that that is to them a way in which that may cancel or vitiate their expert opinion or increase the cost, they will object to it. And when they object to it, I can't imagine arbitral tribunals taking the plunge to go ahead to appoint their own expert in addition to the experts appointed by the parties.
Yes. I'm going to move on to the next question, which actually sort of follows from that, and I think this theme was touched upon by all of the opening remarks. And the theme is, are damages experts seen as hired guns? Jim, we'll start with you. And you think there's a lot of truth in that statement, or is it essentially a myth that professional experts are not essentially hired guns because they obviously have a reputation to protect in the long run? So what's your view about experts being hired guns in arbitration matters?
Mr. Sumit, Khosla, you should offer your opinion first.
Yeah, I think my answer would come along pretty obviously. Yeah, we have a reputation actually to safeguard. So we are hearing actually through our conferences that that might be the case. We have witnessed, I think, some professional ethics that might not be up to the standard, but yeah, I think a serious expert would not jeopardize his reputation by accepting actually something that he does not adhere or agree to. I think the base principle is for an expert is to at an instruction stage to walk away from a piece of expert evidence if he's not feeling comfortable with the instructions given by the lawyers.
Please, yes.
Since I have a reputation of, speaking my mind and sometimes out of turn, let me tell you something that you're probably not wanting to hear and something which is unpleasant. There's several professional interests and personal interests at play. One, for the party feeling less comfortable in the adjudication, to make it appear more complex, drag and stretch it. For the professionals that lawyers are, and even to the extent that some arbitrators may sit back and enjoy the sessions. Unless we have a limitation on party autonomy, it's like gone like a wild horse. There have to be, parties have autonomy in, yes, going to a private forum, in choosing certain kinds, but there has to be some kind of limitation by way of international standards on to what extent there can be party autonomy. Because both in the municipal law and in international arbitration guidelines, almost every rule or every provision begins with a caveat unless the parties otherwise agree. So that has become quite an unruly horse. There is obviously a problem of lack of disincentives in the matter of expert witnesses. While if a matter goes to court, there can be some kind of disincentive, whether it's a remark, whether it's some action taken. But the problem is, as we've discussed over here, most of the awards are confidential, the proceedings are confidential, and therefore, even if someone has deliberately or otherwise attempted to mislead or misled, then there's hardly any action taken in respect thereof. Because how international arbitration is, as opposed to, domestic arbitration, there cannot be any uniform set of rules. It's one of the ills that you take with whatever good comes with arbitration.
So if I may just ask a follow-up on that, if you don't mind. Maybe test that a little bit more. There is, I think, I'm going back to Sumit's point as well. Many of us appear as an expert witness, and that's our profession. And there's some interest to make sure that our reputation stays intact. And that's also because while I believe the awards, of course, are confidential, the community, I think, is quite small. And the word does spread around. And what we have seen is, and I think maybe this is one point to perhaps think about more, is should tribunals name and shame experts more in their awards if they genuinely don't find the expert evidence to be useful or helpful? And that's perhaps one way of the self-regulation mechanism that can be introduced through awards itself. But would you...
The confidentiality, if I may say.
How is it that these reports and the awards are said to be confidential? I fail to understand.
Yes, well, the awards of...
Because ultimately those awards are executable.
Yes.
They can be
Operative parts.
operative
parts. The details are...
Yeah.
But what is the logic or reason behind it? I just want to know.
Because
Right.
the systems or the...
Well, confidentiality is another cardinal principle of international commercial arbitrations. Of course, parties can opt out of it, but as a default rule, all arbitrations, proceedings that takes place, and the awards are not published. And if they go on review or setting aside before
But in a
courts,
challenge to an arbitration award,
Yes,
where
they will-
the proceedings are placed on record before the court, and once it comes to the court under section 34 or 37, all the material is there. How do you still say it is be confidential?
yes. In those instances, well, I can't speak about the practice here in India, but say in the practice in Singapore and our jurisdictions that I'm familiar with, there are applications you can make to seal the record from the public. And that's how you maintain the confidentiality. And say in the cases reported from the Singapore High Court or Court of Appeal on arbitral awards to be set aside, we don't refer to the names of the parties. And of course, you're right, if there is a criticism against the expert, right, but that criticism against the expert by an arbitral tribunal is not something that is likely to be reflected in a setting aside application, because a matter of opinion of an expert is like a question of fact. They are not appealable or subject to review by a court. So therefore, that fact that an expert has behaved badly may be inside the arbitral award, but it will not find itself in the issues that may be before the setting aside court.
May I ask you a question connected to that with your experience? Is there some kind of old boys network at play between arbitrators, specialized lawyers, and experts?
Not that I'm aware of, but these conferences are where we have experts and lawyers and judges mingle. So I don't call this old boys network. I call this getting to know each other.
Thank you.
Carry on.
Sorry. Yeah. Any other? Okay. So I think sort of going from a slightly more negative tone to more positive one.
Can I just add one point to what Justice Banerjee's concern was, which is a valid one from a standpoint of a sitting judge who is interested in the truth and the justice of a case, right? And you would be so aghast to think that, say, an arbitral tribunal could be misled by an expert opinion. So that's why I say there's got to be some limits to party autonomy in which, let's say, like the Singapore courts, only one expert, and therefore let's not have the parties, sort of influence the expert other than what is proper. You can do it if you can persuade either, as we talked earlier, if it is written into the contract at the time of negotiation, or it's written in the institutional rules, right? For instance, if the DIAC were to say, if you adopt our rules, our default rule is a single expert on issues to be framed by the arbitral tribunal. If you have it in your rules, and the parties adopt the rules, that becomes part of the contract, right? The problem with that suggestion is that most arbitral tribunals, institutions, are not likely to want to venture that way. So that's why in one of my comments earlier, I said, Even the duty to be independent, impartial, and to assist the tribunal is not stated in arbitration acts nor in institutional rules, something that we all expect and by convention accept, but it's not stated. So to ask institutional centers to put in that for expert witnesses, the default rule is one, in other words, copy the Singapore model of rules of court, I think you meet with resistance from the institutions. And the reason is this, they give a very good reason for their position, which is the flexibility of arbitration, leaving each tribunal to decide with the parties what is the best outcome for their particular hearing.
Yes, sir. Carry on.
Okay. So like I was saying, from a slightly more negative tone to a more positive one. So let's say we don't do that system and we still stick to the old style and there are more experts who are doing more work. What are the good qualities as counsel, as an arbitrator, do you look for in experts? What makes a good expert in your view?
I think that question should be directed to the judges. I suppose. They are the ones who has to make a judgment. What makes a good expert?
No, actually, our exposure to arbitration, particularly over the last maybe 15 or 20 years, depending on how long we've been judges, have been from the confines of a courtroom. And it's a different point of view than from yours, who actually participate and go out and see what's changing, how it's changing, and the direction that the entire thing is taking. At the end of the day, for the judge, it should be swift and affordable, and it should be fair and reasonable. So we focus on those parameters which may be somewhat different from what the other stakeholders focus on. So what would we like to see in an expert? That he is an expert. But by saying so, not all of us in doing what we do are experts, unfortunately. But we put up a pretense of being an expert. Secondly, there should be an objective basis to the subjective opinion expressed. And the element of objectivity has to be demonstrated against universally accepted standards or parameters. In short, that could be, but if I have to elaborate it, I can spend the next 2 hours on it, expounding it. But that, in principle,
basic that we need looking for. Correct. Yes. You have a question for Sumit?
Well, maybe, sorry, you were maybe not expecting me to answer such a question, but I feel that, well, I would not say what, I would not answer the question. What is
putting you off?
Not a good expert, but at least, and there might be an element of repetition here, I think one of the duty of a good expert is to offer the other side to reach the same conclusion, basis of the same or a similar set of instructions naturally, but to offer the other side the ability to reach the same conclusion as yours is what makes you a good expert. And second, I think goes just the other way around. The ability to factor in the other side's evidence is something, as I feel, that is super important for a good expert, to factor in subsequent reports that he offers to the tribunal, and also through a tribunal's questions. I think the ability to factor the other side's expert's view also makes you demonstrate you are a balanced expert.
Thank you. I think. Sorry, that's not. Do you have something? So, okay. I think that's absolutely fair. And I think, like what Sumit was also saying, is sometimes we are asked, in all fairness, quite difficult questions to answer. And I think more experts can be, I'll use the word objective, but also sort of be clear in how they reach an opinion and provide the relevant, whether it's the standards, whether it's the principles that Mr. Banerjee were mentioning, but also the analysis that's being used to support the analysis, the conclusions, would be quite helpful. we've come across sometimes reports that don't have that underlying documents and support, and it's therefore difficult to decipher or investigate the report further. But even creating that platform or the exchange of information in a complete and transparent way, I believe will go a long way in eventually coming to a better and a more reasoned award for the tribunals. Just a question comes.
Maybe just to supplement, and sometimes counsel would not agree with our approaches, but I think the ability also to explain to the tribunal the areas of agreement actually of an expert, which happens and has happened actually in common hot tubbing that we've experienced with Montek. The ability actually to explain to the tribunal what the areas of agreement can be, despite putting off some counsel in some situations, also I think make you a good expert.
Well, talking about that, of course, it's now almost standard practice. Much as hot tubbing is a standard practice almost for examining witnesses, expert witnesses, the other standard practice is, as I mentioned earlier, an earlier meeting between the experts to draw out the list of what they agree on, and then specifically the areas they don't agree on and why they don't agree on. That's the way in which tribunals and courts are now trying to get as much, how do you say, coincidence of agreement as they can.
Is that a successful way of, going ahead with that?
It still does not resolve the issue. Otherwise, we won't have the need for cross-examination. But there's still a need at times, even despite all these procedures, that the question of which expert view ought to be preferred on certain issues where they differ.
I think just on that, while we are at this, because there was a question on hot tubbing and joint expert reports, and while we are discussing it, maybe we discuss it a bit more. So just on your point, Jimmy, and Justice Nath, your question, if deployed correctly, so just a bit of context to the audience, what are joint reports? Joint reports are nothing when often experts get together and they try to identify areas of agreement between them. So they list those agreements out, and they try to identify the disagreements between them and short reasons for the disagreements. And I think they can be quite useful when you have multiple expert reports on both sides, often to everyone's dismay, over 100 and 200 pages, and submitted, often more than 2 reports are submitted by both sides. So joint reports are a good way of distilling that information into, so like I said, agreements and disagreements, and therefore in that context, when the trial comes, when the hearing comes, it's very clear what's agreed, and therefore you could park that for cross-examination and focus on areas of disagreement and focus the entire hearing on those issues. And I think that also goes to lending more efficiency to the system, because then the cross-examination is more focused and we're all saving time and money. But Jimmy, to your point, I think what we have at least seen, it does little to rectify or sort of do away with the major areas of disagreement. But it's still quite useful for, I believe, tribunals especially, to have one consolidated list of agreements and disagreements in one place, and therefore make the hearing more efficient. And if that is then followed by hot tubbing, another fancy word here, but what is hot tubbing? It's essentially witness conferencing, 2 experts giving evidence at the same time. But that actually lends itself well to hot tubbing, right? Because you have the areas of disagreement, and if the tribunal is well prepared, they can direct the questions to both experts. And coming back to the theme of today's conversation almost, get an answer from both experts on the same issue. So one expert can't dodge the question which he or she may in a cross-examination. So what's your view about at least the use of joint reports in that context and a precursor to hot tubbing, which, like you said, is becoming increasingly popular in international arbitration?
Hot tubbing as a method of taking of evidence between experts taking opposing views have proven to be helpful, but has never fully resolved differences. Because I think whether it is on account of one party's expert still thinking about who is paying his brief, or the fact that there are clearly certain areas of science or art or technology where it's a matter of opinion and not necessarily scientific fact. I mean, as we go into more difficult questions at times at a higher arts or higher sciences, it's a matter of opinion, right? I had one case where we were trying to get a proof of the valuation of the painting You can imagine something like that. You have experts call, but it's a question of opinion. How do you compare? This isn't property where you have comparable properties. This isn't shares where it's public listed. This is specific painting, you know. So you can imagine that in such instances, despite all the attempts, there will be differences of opinion. And in that area, that degree of subjectivity might be somewhat influenced by the party appointment.
Yes, just maybe one comment on that, and maybe directed towards justices. I think the key factor of success for a hot topping exercise to be fruitful is that the tribunal actually adequately prepares this exercise, and it is of a paramount importance that the tribunal actually puts a lot of energy into preparing such a session with an articulated list of questions that he would like to run before the experts.
Sumit raises a very interesting point, which is his point that tribunals or the fact finders and decision maker in arbitration needs to be fully prepared. And I completely agree, but subject to two comments I need to make. First is that arbitration awards are not appealable. So as to which expert an arbitral tribunal prefers is not appealable, right? So if it is wrong even by subsequent review, but that's still a question of fact or opinion evidence, and that's not appealable. So with that, there is a slight degree, or perhaps not so much of the arbitral tribunal's decision is not subject to review on this area. So there is not enough of, in my view, a push. The second thing is that in a hot tubbing session, the arbitral tribunal takes the lead, unlike questioning of witnesses of fact. So the arbitral tribunal must be the one taking control of the questions being asked and directing which expert to answer. And so to that extent, it does require the arbitral tribunal to be competent as well, both in terms of the procedure of taking such evidence, the diligence of studying the papers, and finally, hopefully, a certain familiarity with that area of dispute. I mean, be it construction, so you have people who are construction lawyers, you know, in the field of oil and gas, lawyers who are experienced, arbitrators who are experienced in that area. So that helps. Yeah.
So I believe Sumit has one more question, and then we go on for the open house.
I think we can do that, yes. I'll ask the last question, perhaps. And it's a sort of a loaded question, so I'm not sure how much we can do in the minutes we have, but very, very quickly, because I think it's useful to, I think this also goes back to the whole theme of self-regulation and also perhaps how we can make awards more robust when it comes to expert evidence. And maybe quick views from everyone on this last question before we open up for Q&A. Jimmy, I'll start with you again. As counsel, as an arbitrator, do you think commercial investment, commercial arbitration awards do justice to quantum issues? In that, are they well reasoned enough? Are the awards spending enough time on quantum issues? And I think it goes back to the point about reaching an objective or a reasoned award on damages, for example. If there's more guidance given perhaps on awards and more reasoning given to support those quantum issues, perhaps it also will help the tribunal, the counsel and the parties understand whose evidence was preferred and why, which hopefully then creates the cycle of using experts who come across more reasonable and are perhaps adopted by tribunal members more often than not.
Well, much as an expert tries to vouch for his own professional integrity and uphold it, the same with the arbitral tribunal member. Mm-hmm. They too will want to present a reasoned award, a well-reasoned award, so as to, how do you say, ensure the continued integrity that he has before the arbitration community. So we've had cases where arbitrators have taken a long time to give an award. or that the awards are not easy to understand from what their reasoning is, or certainly in these areas of complex expert evidence on scientific or engineering issues that the reasoning may be flawed even. But because there is no appeal, I think that area at best is somewhat limited in terms of criticism.
So, very well. Now we have an open house question-answer sequence for about 15 minutes. All those who are interested may please raise their hands. One by one, we'll go.
Yeah, there's a mic coming.
Thank you very much. So, confessing, I am an expert or an expert witness, but I'm going to go for you to identify yourselves. Oh, sorry, Jonathan Ellis from HKA. 2 points, mostly around process, actually, which is one thing about international arbitration is it needs to be for any party, from civil systems as well as common. And so the requirements for an independent expert is ingrained in the common law system, but is less so in the civil system. You still need to convince the adjudicator, the judge or whoever, the tribunal, but the independence of experts is not codified in a lot of those civil jurisdictions. So the rules for SIAC and everything else don't have that requirement in there. The IBA rules are quite set up towards that. You have the Prague rules on the other side for the civil side, which I haven't seen in practice at all, but there isn't that same requirement between those two systems. And it's very interesting when you have parties from a civil jurisdiction and a common jurisdiction who choose international arbitration as their kind of venue or fora for resolving their disputes, and how the two different parties approach the expert process is really interesting, because the tribunals are international, and so there's a slight favour towards the common law process. Maybe that's because they're appointing people like me to be in that, and I come from that side. But that flexibility needs to be there, but depending on the parties, was the first comment. And the second one about hot tubbing, it doesn't need to be tribunal-led. You can actually have, and Australia is the front runner in this, you can have expert-led hot tubbing, where experts question experts. And that is kind of, Australia were the first people to get in the hot tub, or kind of enforce the hot tub on experts. Kind of probably quite good, given their weather. But there's expert-led, there's tribunal-led, and there's counsel-led. And it's not codified what hot tubbing is at all. It's not in any rules. The CIR did some guidelines on that, which hopefully tried to shed some light on what could happen. But it's not kind of codified. And the Singapore rules, 2021, they talk about a panel, but they don't go further than that. They kind of leave it very flexible as well. So there's lots of flexibility in arbitration. I was just kind of, you need to look for guidance about how your parties want to do it.
More comment. Yes, anyone else?
Yeah. I'm Sanjib. So the topic is role and duties of experts in assisting the arbitral tribunal. By taking the assistance of arbitral tribunals, the experts, is the arbitral tribunal not really delegating its powers and duties to the experts? Ultimately, on the basis of whatever expert evidence, which is a part of evidence led by both parties, the tribunal has to... The
tribunal is never bound by the expert opinions. It has to take an independent view.
That's right. That's
partly or fully or only whatever.
So if the...
Only an advisory, this thing, the expert opinion is done.
So that's... So that's why I'm saying, if the facts witnesses are already being examined by as experts by the two parties, and they assisted by the counsel, assisted by the experts, can cross-examine the witnesses, that reduces the substantial costs also of the tribunal. Otherwise, experts appointed by the tribunals add to the arbitration cost substantially. That has also been noticed.
May I just deal with it with an everyday example? You know, in a criminal case, for instance, you have the factual witnesses, but you also have the medical examiner on the post-mortem report. That's an expert witness.
Or an official,
Or the FSL report. So whatever, you have expert witnesses. And to the extent that what is found on facts is substantiated by the expert opinion of the expert, it's open to the judge.
Yes, that's an ultimate.
No difference.
So ultimately, the judge should, the arbitrator should decide on those. Yes, yeah.
yes. Yes, next question.
I think Mr.
Gentleman here in the middle. Mr. Gandhi.
Yes, a few observations in the light of the discussion that you had. The experience shows that the
A little louder.
Yes, please.
Yes.
Am I audible now?
Yeah.
Okay.
Better.
In most cases, you will find that the experts are chosen and appointed by the solicitors who handle the cases in the international arbitrations. And these solicitor firms have a very large number of clients, and you get to see the same expert being appointed from one case to the other to the other. It's not the parties who chose. One other aspect you would see, so therefore whether they're independent or not would have to be found out from what they produce as a report. And as I think our friend just mentioned in his slide, that Sumit, he gave a slide. The very concept that you have what is called a first round of expert report, then you have a rebuttal expert report. Now the very fact that a rebuttal expert report is almost like a rebuttal evidence on facts by the witnesses. There is hardly any difference. So therefore, it's true, it is very difficult to get that kind of an independency. But in any case, the tribunals are well trained. The lawyers are also well trained. They know how to get about it. I can tell you one of my experiences. A very well-known expert was being cross-examined. During the break, when he was getting up, unfortunately the mic was on, so I could overhear what he said. He told his solicitors, this is the reason why I don't like to give my opinion. He doesn't like a question being asked. Most experts would like that whatever they are presented, you should accept it. And right, the present trend of what is hot tabbing is there's no universal rule. It is true, as I think Nath has said, if the tribunal is well prepared, I think one of you said that. If the tribunal is well prepared in advance, at that stage if the expert witness comes, they're in a better position. But it really doesn't happen that way. But as you know, it is post-evidenciary hearing that the actual oral hearing takes place. So at the stage of evidenciary hearing, the tribunal is not fully apprised of the nuances of the case.
No, but there are systems or practices where there are preliminary hearings by experts addressed to the tribunal, so that they get a clear view or a basic concept of the whole issue. And thereafter the main proceeding starts. Is that correct?
No, this is nothing right, but I don't think there is a practice of hearing the
apprised of the actual issue which is coming up, maybe in its technical form also.
The parties do an opening submission. The parties are called upon to give an opening submissions before they go in for the evidentiary hearing. That is true, but they give an overall picture. When the expert witness comes in a detailed manner. Another thing that was being said was whether the parties can appoint an expert. You will find in a long-term contracts, there are such provisions.
Thank you. Thank you. Great. You will get a chance, young man.
Yes. So I'm D.S. Mahindru, advocate practicing here and an arbitrator with the DIAC. Since 3 days, I have been attending the sessions, and it has become eminent that India has to become arbitrators' hub, like Singapore, Dubai, as I have been. Would it be appropriate that because commercial arbitrations in our domestic arbitrations, commercial disputes are also gone through by 96 Act and the statute which provides. So there is a necessity now that we should also incorporate the duties, functions and limitations, do and don'ts for experts in their fields.
What do you say?
Ideally, but they vary from the nature of the expertise so much that, there would be another set of rules without there being anything specific. And again, you're asking the legislature to legislate, which of course is another gray area. So
we are going to have our law minister next.
no. It would be best if it's left to, as more or less agreed, party autonomy, and if there's institutional arbitration, the rules of that institution, which have to be wide enough to embrace everybody. Because if you constrict it, then you're not attractive for people to come and avail of your institutional arbitration. So those are the flip sides of the system.
So just one quick comment on that, and just so you're also aware. I mean, we discussed at the beginning. Jimmy and Sumit both discussed this, I believe, on the certain protocols and guidelines already available internationally, and we are finding increasingly those guidelines being used in arbitrations, even in India. So in the procedural order, they'll mention the use of those guidelines as a set of rules essentially to follow, which provides some conformity and some uniformity to the process. So hopefully that also aids in making the expert evidence more robust in that particular arbitration.
So this young man over there has been raising his hand from the beginning. Sorry? Just a minute.
Aditya Vaibhav Singh, I'm an advocate on record on the Supreme Court of India. My question is that hot tubbing is something considered inquisitorial to some sensibilities, and it is being practiced in the adversarial system for so long. Mr. Yims said that it hasn't achieved the desired success. So shouldn't be tweaked and applied in a sense that it is more appealing to the sensibilities of an adversarial system, like my friend here pointed out to the Australian experience?
Yes, Jimmy.
You're right that in an adversarial system, you will necessarily have to have the clash of swords and steel to produce the best result. Yeah, but we are talking about in the field of expert evidence is on the subject that if certain scientific principles or engineering principles are established, the question is, or accounting principles, why would, in certain instances, experts would differ so considerably? So if it is a matter of opinion, like I said, on the subject, like say valuation of an art piece, I can understand. But let's say if it is on established principles of science, engineering, or even foreign law, it is to say at times surprising. And so the statistics reviewed by Justice Banerjee from the report that experts feel pressured by the party appointing them to give opinions in their favor. So is this part and parcel of what you desire in an adversarial system? That's a philosophical question.
Thank you. One last question. Yes.
Just an observation in response to the process question that arose. And also partly in response to what Justice Banerjee observed about experts and in a murder that you've got the medical examiner. A lot of the discussion naturally has been on the basis that the experts go away, they write in a report, they confer, and the first time the tribunal really engages with them is at the final evidentiary hearing. That needn't be the case. What you see in a lot of international arbitration is the tribunal becoming involved with the experts very early on. To take an example, HKA will be familiar with in programming. There are different ways to calculate the programming issues in a construction contract. You see tribunals who will say, right, the first thing the experts will do is they will meet and they will discuss and they will agree the methodology for analyzing the program. And if they can't even agree that, they write a report back to the tribunal as to why they agree. The experts then go off and they're analyzing everything on the same basis. And by engaging in that constant way, actually by the time you get to the final evidentiary hearing, you really are, as Jimmy observed, you really are testing why these two professional men differ on tiny, tiny, tiny things.
Thank you.
Useful comment.
So, sorry, ladies and gentlemen, we are now closing the session. Go ahead with the valedictory, which is shortly scheduled. And I believe all of you have had a good time and some meaningful and very lively discussions over here. And you go back with some benefit out of this session. Thank you, all my panelists and speakers. And thank you, audience. Thank you very much.
Thank you, sirs, for the enlightening session on the role and duties of the experts in assisting arbitral tribunals, and also for sharing the innovations in ensuring impartiality of the experts. Thank you so much, sir. We shall be having a short break of 10 minutes, and we'll be back for our final concluding session. Thank you all.
When I get back, so I should get back before if you're in the hotel for 6. Should be. Oh, your phone. Ah, okay. Well, if I might go back to the hotel before going to Taj. Absolutely. Yes. This way?